Hi, everyone. Thank you so much for joining us for the February Cannabis Industry Meetup. I am super excited to have this topic, which is predatory lending, which is incredibly important in the cannabis industry because, as you know, banks, small business administration, things like that are not accessible. So we have William Wolf and Bart Chachia, correct, Bart?
It's actually pronounced catch-eye, but I can't blame you
Cat
for pronouncing it wrong.
Catcha?
Catch-eye.
Okay, okay. What he said. Um, so um, thank you for joining us again, and we will be sending you a link to this recording if you can't be with us the entire time. But Will or Bart, whichever one of you are starting, take it away.
Thank you, Jennifer. As she stated, my name's William Wolf. I'm an associate at Harris Beach. I'm hoping I'm sharing my screen correctly. It says I am. If not, someone please stop me. But me and Bart are going to discuss predatory lending, but also how can cannabis businesses raise funds. One moment. Now, as many of you may know, most of you may know, cannabis is currently legal in about 40 states, both medically and recreationally. But there are 19 states, including Washington, D.C. and Guam, that have legalized cannabis for recreational use, despite it still being illegal federally. Now, states that have legalized either recreational or medical cannabis have done so in direct conflict with federal law. And that creates a tension between the states who feel as though they have the right to create their own laws and, of course, the authority of the federal government. Now, President Biden, at the end of last year, declared that he wanted to reschedule cannabis. But as of today, cannabis is still scheduled as a Schedule I drug according to the Controlled Substances Act. Now, that means that the government believes that it has no medical use and a high potential for abuse, and the cultivation, distribution, and possession of marijuana still violates federal drug laws. Now, most cannabis businesses can be separated into two categories. You have plant-touching businesses, and you also have cannabis ancillary businesses. Both of those businesses have difficulty accessing capital that would otherwise be available to other businesses. Part of that is because of the way that banks treat cannabis businesses and businesses associated with the growing or selling of cannabis. Now, the SAFE Act was first passed by the House in 2019, but as of today, it still has not been considered by the Senate. And the SAFE Act is important because it can potentially allow for these banks that currently will not touch any business related to cannabis, allow them to receive funds from cannabis businesses and also distribute loans to those businesses. Now, there's a few pros and cons to the approval of the SAFE Act. One of the pros, of course, as I mentioned, being that these banks will no longer be liable under federal law for providing loans or financial services to legitimate businesses. SBA loans and other traditional funding sources will also likely become available. But there are some cons as well. And one of the biggest cons that cause a lot of concern is that the approval of the SAFE Act still really has no bearing on its scheduling according to the Controlled Substances Act. It would still be considered a Schedule I drug. And also the approval would not legalize the nationwide use of cannabis. Now, in addition, the SAFE Act would terminate or limit the insurance or share of insurance that a financial institution would be liable for because they provide financial services to legitimate cannabis-related businesses. The SAFE Act will also prohibit or discourage depository or financial institutions from offering financial services to such businesses. And it also penalizes a depository institution for engaging in a financial service for such a business. Now, part of the reasons why cannabis businesses fall victim to these predatory lending practices that we're going to touch on a little bit later is because of the risk associated with cannabis investments. As I stated, under federal law, cannabis is still illegal. So businesses that sell, distribute, grow, or even create the equipment used to grow cannabis are still operating illegally. So that means that these businesses do face criminal liability. And this is considered a direct risk from a cannabis investment. Now, although any investment into a cannabis-related business will expose investors to some risk of criminal or civil sanctions, that hasn't happened for quite some time. The federal authorities have not pursued to enforce any laws against investors where cannabis is illegal on the state level. Now, for the cannabis ancillary businesses or the businesses that are considered to be non-plant touching, they face some difficulty as well, but it's less risky than those direct plant touching operators. And part of that is because there's an additional step removed from the cannabis ancillary businesses. For example, if an investor knowingly provides capital or services to an ancillary cannabis business, then sells its product to plant touching businesses, a direct charge of the Controlled Substances Act violations of aiding and abetting are unlikely because, again, there is that additional step that sort of removes them from that criminal liability. Now, with the direct businesses or the plant touching businesses, this is considered the highest risk cannabis investment structure. And that's mainly because the investors themselves may not be engaging in cannabis related activities, where they may be liable for criminal charges, but they are funding those organizations, at least based on the way that the Controlled Substances Act is drafted. It can be considered that they're aiding in furthering criminal acts. Now, predatory lending practices are currently plaguing the cannabis industry because of those high risks that I just mentioned. When there's a business that's operating and it's operating in violation of a federal law, a financial institution that relies on federal dollars is not going to want anything to do with that investment. So that leaves the person looking for a loan to go to less traditional options such as a private investor. And oftentimes those private investors can have loan terms that may seem unreasonable. And they also offer some loan to own models. Unreasonable term loans are probably the most common, and that is usually where you have incredibly high interest rates being charged or other requirements that you don't really see with a traditional business. The loan to own model is an instance where you have some businesses that are actually using their cannabis licenses as collateral on a loan. But as Bart's going to discuss right now, there's a big difference between predatory lending practices and practical lending practices. So Bart's going to take it away and discuss how to recognize the difference between the two, and also some practical risk mitigation steps that can be taken by your business in order to secure the funding necessary to help your business grow, while also avoiding those predatory lenders who are just seeking a high payday.
Thank you, Will. So I am Bart Ketchai. I'm senior counsel at Harris Beach. I've been practicing corporate law for, oh boy, 17 years now. And I've counseled a number of clients, I like to say from startup to succession. So I've done plenty of capital raises with clients, plenty of financings, both debt financings and equity financings with clients. And this industry in New York State at the moment presents quite a challenge in that regard, as outlined by Will. And really, it comes down to a tension, as he mentioned, between the federal rules and the state rules. And there is a light at the seemingly endless tunnel of regulatory reform, I think. The SAFE Act is very promising, although it still hasn't passed the Senate. If it does pass, and I can't imagine it won't at some point, I think the floodgates for bank lending and banking relationships will really open. Not all banks will be comfortable, given the tension that still exists with the scheduling of marijuana and the legality of it at the federal level. But I do think that a lot more institutional lenders will provide good access to capital for a lot of cannabis businesses in New York and throughout the country. So that's sort of the promising news. And the good news is that right now, although most lenders are very shy to get into a banking relationship, whether it's a depository relationship or a lending relationship with cannabis businesses, they are not non-existent. There are some guidelines that were issued back in 2014 by a federal agency that give banks and other lenders, institutional lenders, some comfort in having relationships with cannabis businesses. So it's not entirely impossible. And we are starting to see some activity in New York State from banks and in particular credit unions that are starting to open up a cannabis line, if you will, or a cannabis department. And to that point, and to Will's point that he segued to me with, there is a difference, and I don't want cannabis businesses to shy away from what I'll call practical lending versus predatory lending. You can pretty much anticipate, given the risks involved, that loans to a cannabis business will come at a bit of a premium. And I'm not talking about 10 points of interest. I'm talking about a couple of points of interest. So if their standard or customary rates or going rates are 6 or 7%, they may charge a little bit more to a cannabis business given the risk involved. The other costs to the bank that they'll try to cover are the administrative costs. I mentioned those guidelines. Those guidelines require enhanced disclosures that the borrower will have to submit to the bank, and that the bank will have to, or the institutional lender will have to review very carefully in order to make sure that they're in compliance with those guidelines. So there's an extra administrative cost to the lender that they're going to want to cover either through a fee up front or perhaps a point on the interest rate that they'll be charging the borrower. So
Bart, can I just ask a quick question? I'm sorry.
Sure.
So loan to own model, I mean, how does that work? I mean, in New York State, in the terms of that, the licenses are conditional and non-transferable.
Correct. So, and again, the loan to own models that you see in predatory lending are sort of overkill. In other words, a lender might say, okay, not only do I want a promissory note, which is basically the borrower's obligation to repay me, I also want the ability to get equity. So if the company does do exceedingly well and the shares are worth a good amount of money, I want the ability to buy in at a discount. And predatory lenders will typically negotiate a very inequitable position there. So they'll take either too much equity for too little, or the whole company for too little. And so that's what you want to be wary of when you're negotiating with any lender, whether it's a private lender or an institutional lender.
But if you had a loan from, whatever person and you failed to pay them back,
Mhm.
that doesn't mean that they then get control of your license while it's conditional, correct?
That is correct. I mean, unless they take a secured position. And again, that presents its own challenges because, to your point, Jennifer, which is a very good one, even if they have a secured position, let's say on your assets, the bulk of a cannabis company's assets, whether it's a cultivator or a retailer, is going to be inventory. And the bank or the creditor, the secured creditor in this case, is not licensed to take control or possession of that collateral and sell it and try to make up the repayment of the loan. So it's a challenge for creditors to structure their loans in order to get that kind of security or get more traditional security, but it's not impossible. And one of the other things we expect to see, and we are seeing, is what's called convertible debt. And that is a situation where a lender will get a promissory note, but it's a convertible note, and certain triggers will trigger that note to convert to stock, to equity. So that's a scenario in which the lender is really trying to protect the downside. So if the company doesn't do really all that well, at least it still has its position as a creditor and its
What would
rights
some of
are-
those triggers be?
Usually it's a liquidation event of some sort, an IPO, for example, or a stock sale. A movement of the company from one group or one person
Right.
to another.
So if it's an
Usually.
initial public offering, they're probably not losing money.
Oh, definitely not.
Yeah.
If you get to that point,
Okay. Yeah.
even if they're just a lender, a straight lender with no conversion, they're gonna make their investment back and whatever interest rate they're getting back for sure. And yes, again, to protect the upside, a lot of these lenders will, or investors really, will ask for a convertible debt instrument, which at that time, in your example, Jennifer, if you're going public, your equity has significantly increased in value. You're not going to go public if you don't have, very valuable equity. So what the investor is going to want in that situation is not, let's call it an 8 or 10% return on their investment through an interest rate. They're going to want to convert to the equity and get paid out with all the other shareholders at a much larger return on investment, most likely. So I wouldn't advise folks to shy away from terms like that. They're not predatory, unless again they go overboard, unless they're trying to reach into the company and grab too much for the value that they're providing to the company.
Is there a specific interest rate, or do you have a specific algorithm for, this amount of money should get you this amount of equity?
It all depends on the stock price, or what you might call the strike price at the time of the conversion event. So really it's unknown initially. It's contingent initially when the person makes their investment, but it will basically convert, and different convertible instruments have different conversion rates. But obviously that's something that a borrower or a target company and their portfolio company and their counsel are going to want to look very carefully at. So again, if it feels inequitable, if you're looking at a proposal that a prospective lender is making and it just feels like the interest rate is too high, or their ask for equity or their equity kicker, as they sometimes call it, is just too much in your mind, it probably is. That's the simple answer. And there's other, in a weird way, the rules in New York, and I think Jennifer alluded to this earlier, with regards to equity and who holds the equity, persons in interest, and things of that nature that the state is going to look at on a regular basis, that can give you some leverage. Because the fact of the matter is, for example, if you're a social equity candidate and you apply for a license as a woman-owned business, as an example of a social equity candidate, there's going to be a period of time during which that can't change. The state will not allow a change in control, simply will not allow it. It goes against the whole purpose of the social equity the purpose. And so there's going to be a period of time during which your equity is sort of locked in by law, which is kind of a strange concept, but that's really what's going to happen. So that will give borrowers, cannabis businesses that are looking to borrow money from lenders, and even perhaps issue convertible instruments to investors, some protection against a true predatory lender that's just looking to take over the company through the guise of debt. So that's good news. But the real issue here for these startup cannabis companies is and the real challenge is they're facing what's already an inherent risk. There's a significant risk, particularly in New York State, where the market is very new and certainly unproven. To pitch this to whether it's a lender or a investor, an equity investor, is going to be very challenging. Investments in startup businesses are already risky because they're highly speculative. There's no runway to look at. You're not looking at the performance of a business over the last 5 years. You're looking at a true startup company that has no performance history.
There are industry surveys through like IBIS World that analyze the recreational market in other states and value
Absolutely.
it in the billions. So can you really say it's an unproven
Well, that's exactly, it's still highly speculative. While you could say, okay, for example, if I'm a cannabis dispensary and that plans to open up in Monroe County, well, let's take a look at a similar county in Colorado that has a similar population with similar demographics, and let's see how that dispensary has done, and let's use that to project. Well, again, at the end of the day, it's still speculation. It's still projections. It's not actual performance. That business in Colorado is managed and operated by a different group.
True.
They have access to different employees. They have access to different cultivators, et cetera. So,
True.
Investors are really going to be, for lack
But
of.
I would also ask, and I honestly don't know the answer to this, have any of those dispensaries gone out of business?
Right. So they're going to be very skeptical. That's my whole point. Like, investors are going to be very skeptical up front, which they tend to use as leverage. But again, with high risk comes high upside. Yes, this is a highly risky investment, highly risky loan, but it has tremendous upside. To your point, Jennifer, there's billions of dollars in this industry, and it's generated billions of dollars. In Canada and in states where it's legal. So, I think your sophisticated or accredited investors are going to understand that. They're going to understand that it's a high risk, high yield type of investment. And so, again, I just want folks to understand that when they go to raise capital, there are going to be, it's going to fall into that category because it's high risk, high yield. Yes, everybody hopefully will get a big payout at the end of the day, but the upfront risk to the investor who's putting the cash on the table is going to come with some contingencies that aren't necessarily predatory in nature. And I think a good attorney is going to help you discriminate between those. To the extent that somebody's overreaching, a good attorney will let you know that, but not to the point of blocking you from potentially good capital. And so, and on that note, I do strongly recommend, not only having a good legal counsel to go in these negotiations with, but also a good CPA or accountant, because a lot of the structure that informs the investment terms will also be driven by, you know, the accounting goals and the tax mitigation, if you will, of the founders of the company. And that takes a really strong CPA to work with in terms of choice of entity, whether you're going to make certain tax elections to save taxes. So I strongly recommend having a good legal team and a good accounting team in your corner.
Yeah, I just like to say, you know, the clients of the Business Insight Center at the Central Library, they do have access to an accounting firm, CPAs, that specialize in cannabis.
Excellent.
So if you have any questions for a CPA, we can arrange for you to meet with them at no cost to you. And they're really wonderful people and they're happy to help. So again, just reach out to us if you would like to speak with them.
That's fantastic. That's a great resource. Thank you, Jennifer. So, you know, getting back to the tensions between, you know, and that's the other aspect here, is that not only is it a risky proposition in any industry, it's particularly risky in this industry because you sort of have this tension of, well, the New York State rules are requiring applicants to have evidence of capital. You know, they're not just going to give licenses to anybody off the street that doesn't have the capital to get their business off the ground. So the on top of the inherent risk in a startup business, you've got the licensing you know, regulations that are making things a little bit more challenging, because an investor is going to look at this business and say, wait a minute, you're not even licensed yet. That's a risk for me. What if you never get licensed? What if your application takes a lot longer than you expected and we don't start seeing profit for another 3 or 4 years? So again, I'm just trying to get people in the minds of an investor and the kinds of questions and concerns and hesitations that we're seeing with our clients when they go to investors. And it's unfortunate because, you know, if the rules and it's tough to gauge sometimes, because the rules seem to be kind of ever evolving, and they're not, you know, particularly for the card licenses. Sure, I think some justice involved folks have gotten their conditional licenses, but there's still a lot of social equity candidates waiting in the wings for these rules to settle. And so they're doing the responsible thing and trying to get out in front of capital raising and having that capital, you know, evidence of that capital, not only evidence of it, but actual capital, you know, and when they go to apply. But it's really tough for them to put the chicken before the egg, if you will.
All right, can I just, I'm sorry, I keep
Sure.
interrupting you, but I have actually called every New York State chartered bank in the Finger Lakes region. I've also called every credit union on a Native American reservation, and none of them will touch it.
Yep. Yeah, that's
Like,
we're not seeing much activity in this neck of the woods, but I can tell you that in the Capital District, there is a I want to make sure I get the name of this right, so I apologize. Give me 1 second. There is a credit union that is starting to reach out and advertise a cannabis banking arm.
is it in Massachusetts?
No, they're a credit union in the Capital District. Why can't I find it now? I believe they're called SunTrust. Now, I don't know if they're open to banking relationships, whether it's depository or lending with cannabis business outside of their market. I don't know the answer to that, but there is that was the best news I've heard. Just in terms of access to capital, that was the best news I've heard in quite some time.
That's great. I mean, yeah, even if it's just banking, I mean,
Yep.
that is fantastic, fantastic news.
Yeah, so I'm hoping that that will be sort of the start of the gates to open up. I mean, I think ultimately market pressures will just get banks, credit unions, financial institutions to start, operating a cannabis business, operating a cannabis arm. But it's slow because, again, I think that the key here is that everybody's it's Sunmark, it's Sunmark Credit Union. And so they're again in the Albany area, but they may be open to banking relationships with businesses outside of the Albany area. I haven't looked into that. But I think everybody's waiting for these rules to sort of come to rest. And they're also waiting for that federal attention to release a little bit with the passage of the SAFE Act, which again, there's no guarantee of. Unfortunately, it's just gotten stuck in the Senate and it hasn't really budged. One of the other, again, so all of this just makes access to capital very challenging. And so, we've had to get kind of creative with our approaches to investors, to the extent that the investors are a little bit gun shy, if you will, and just not willing to take the risk associated with a pre-licensed cannabis business. We may structure it as, okay, well, then let's play it this way. You put in a good faith deposit to let us know you're serious. And then once you get licensed, you're obligated to make a contribution to the company, either in the form of a loan or in the form of an equity purchase. And you risk forfeiture of your deposit at that juncture. Now, I can't answer the question of whether or not that's going to be good enough for the state in terms of actual capital invested. But that's one solution that we've come up with clients to attract investors. So there's just a lot of barriers, I think, that are presenting a lot of challenges to these companies that are just trying to get off the ground. Access to capital is certainly a huge barrier right now, but we're hoping that those sort of restrictions and restraints will start to ease up as the federal rules change and as the New York rules come to a rest. Couple of other topics we want to discuss just in the area of capital raising. Depending on the types of investors that you're going after, you may want to look into securities law compliance as well. A private offering to investors, and presumably everybody's going to be doing that, may require certain disclosure requirements, or certain disclosures be made to those investors prior to the investment in order to comply with both federal securities laws and state securities laws. So again, having a good legal counsel in your corner that has that expertise will be very beneficial to you in the long run. One other thing we've seen, or trend we've seen, is U.S. cannabis companies looking for access to capital on the Canadian public markets. So trying to get listed publicly on the Canadian exchanges where cannabis companies are listed. The issue there right now is just those exchanges are flooded with cannabis businesses, so it's highly competitive, and getting accessing capital from that avenue is going to be very challenging. Again, as I mentioned, be sure before you go to investors that you have consulted with an accountant so that you understand the tax structure, not only from your point of view and the company's point of view, but also your investors' point of view, so that you can have those discussions with investors. So I'm just trying to think, are there any questions on either the predatory or practical lending issues that we've discussed, or any other access to capital items that we've discussed?
Yeah, me again, sorry. Are you familiar with any of the venture capitalists uh, that are strictly funding cannabis? And if so, are the terms or favorable or reasonable?
The only one I've come across is actually a Canadian fund. And and I'm glad you raised that, because it reminded me that if you go, outside of the public markets in Canada, there are private equity funds and other potential financial partners in Canada. The challenge there is particularly in a partnership deal or a joint venture deal where you're partnering up with a company in Canada, which probably brings a lot of value to the table because they have a lot of experience with owning and operating a cannabis business. But there's also some tricky tax issues, particularly under the Canadian tax rules, that I'm certainly not aware of. But you're going to have to most likely make some concessions in the structure of your company and the structure of your investment in order to satisfy the Canadian partner.
But there's VCs in the US that
There are, but they're again reluctant right now in New York State in particular.
yeah.
But certainly, there's VCs and private equity funds that have, and I'm glad you mentioned that, Jennifer, because those are the types of investors and players that are going to propose what might appear to be predatory terms, but in reality are very much market for private equity and venture funds. They are taking a very significant risk when they invest in companies at a very early stage.
Yeah,
I mean, highly speculative.
Yeah, I mean, I work with companies of every ilk and every stage, and a lot of them are like, I want angel investors or I want VC funding, but you have to understand that you're giving up equity.
Mhm.
None of them are going to give you money without equity. So, and then I know it's kind of like a fine line to walk with cannabis of like, what is that reasonable amount of equity?
Yeah, that's correct. And that's, again, from the investor's point of view, they want to protect the upside. They want to be able to, okay, instead of getting a 12% annual interest rate or whatever, I'm going to get a 6x return on investment. So that's why they go after, that's why they will go after equity for sure. But again, the one tool that you have as a cannabis business in New York in your corner is a change of control. Like if they're going for more than 50% of the equity of the company, that's going to be an issue from a regulatory standpoint.
Yep.
So you have to explain that to them up front, that even if you don't want equity up front, if you're just, let's say, negotiating a convertible instrument and you're lending so much money that eventually is convertible into so many shares of the company, that can't exceed under any circumstances 50% of the company, because that would trigger a change of control, which would have to go to the state for approval.
And also,
most investors will say, no, we don't want to go to the state for approval.
If you had that much equity, then you would also become a true party of interest. And then you're limited to you're limited to 3 investments.
Right.
Correct.
And that's the other thing that's a good point. And the other thing that I want folks to understand, and for their investors to understand, is that the state will look into any source of capital, whether it's a shareholder or shareholder equity or a lender. And they're going to look into,
or a landlord.
Right. They're going to look into whoever has a real economic interest in the business. And, by way of a parallel example, in the liquor industry, an active police officer cannot have any financial interest in a business that has a liquor license. So, there may be people in the chain of ownership, if you will, or chain of economic interest, that are on the no-no list. So you have to be very careful about that and explain that to your investors, that they may be subject to some disclosures. They may be subject to some background checks as well.
Yeah, the true party of interest aspect of the license is a little bit makes you want to get a lobotomy, I guess, is kind of my takeaway from it. The part about it that I find most interesting is that your spouse is automatically a true party of interest, but your child is not. So that's kind of one of the things where I'm like, that's interesting.
Yeah.
But
It's
yeah. So but again, there was regulations. The comment period is ending soon.
I think the 13th, if I'm not mistaken.
Yeah. And so then we'll have another whole round, most likely, or not. Um,
I
yeah,
imagine there'll be another round for sure.
you think there'll be another round of comments?
Yeah, because that's one weird thing that's in the regulations. There's a bunch of proposed regulations that cause some concern. So I'd be shocked if there's not, another
Yeah, I
round.
mean, my understanding is the regulations have some aspects of it that are actually illegal, so people will be, I'm not saying you, but other people will be bringing that to the attention of OCM. So yeah, that'll be,
well, and
Yeah.
we're advising our clients to anticipate, the application opening second quarter, possibly third quarter
we do
of
have
this year.
a question. Thank you, Wendy. What do you consider the biggest area of concern in the regs?
Well, I don't have enough regular interaction with the regs to advise on that. I've been mainly counseling my clients through, the business side and capital raise side of things. I don't keep tabs on the regs, but I think it's for me, and the challenge that they present to me, it's that restriction I was talking about, the change of control restriction. How long is that going to be in place? How long until the state sort of opens up the door to bigger transactions for these companies that have gotten off the ground or doing really well and now have a very, very valuable asset that they can sell. And how long is the state going to keep restrictions on things like change of control? And so that's what presents one of the bigger challenges to raising capital, because at the end of the day, the investors are going to want to know when they get their payday.
William, what are your thoughts on what Wendy posed?
Well, in addition to the true party of interest and all the disclosure requirements, I personally draw some concern as it relates to the proposed disciplinary regulations and what happens when an entity may forget a disclosure and how long before they have to cure it and things like that. It was that section of the regs where I had a lot of comments to submit. And I believe the New York State Bar Association, the Cannabis Law Section, as an organization, they are also proposing some comments to OCM as it relates to the regulations. But I think as a whole, they need to be cleaned up a little bit. But I understand, it's a completely new branch of government, and that's the thing that, oftentimes we don't think about, it's not like this branch has been around for 2, 3, 10 years. They're new. So, they had to go out and buy things like staplers and get chairs and then get people to sit in those chairs. So I understand stuff like that takes some time, but
Right.
yeah, hopefully things pick
But
up.
there were also precedents in other states to model. I mean, they had many opportunities to learn from other states.
And they also had to look at the mistakes of those states in
That's
order to
correct.
try and make it better.
Yep.
So, I'm pretty sure they took all of that into consideration, and, it was actually Governor Cuomo who passed the martyr, and then he had his whole situation, so that caused some slowdown. So I understand why it took some time, but
Yeah.
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 But hopefully, once everything, gets finalized, New York will be in a better position than most of those states, because
Mhm.
they had the opportunity to look at their successes and their failures. But we'll see.
Yeah, Wendy says, thank you, and I agree with TPI issue, but I get what they're trying to prevent. Yeah, and I agree with you. I mean, they're trying to prevent some sort of conglomeration from taking control of the supply chain. And I understand that. And it's, in my opinion, and I'm no one, my opinion doesn't matter. They're kind of overcorrecting, but that's just me. So, but yeah, I understand they're trying to prevent any group of people from fully verticalizing, and I get that. But we'll figure it out, right? We'll figure it out is all I can say.
One other
So,
topic, real quick that we didn't cover, but we did outline a little bit in our prep, and it goes to the kind of slow moving evolution of this industry in New York State, is the status of the social equity fund that was set up. The state had set up, or more, I shouldn't even say set up, but provided for a $200 million fund that would have given some of this capital to these cannabis businesses, primarily, actually, I think exclusively for property development. There's a lot of regulations specific to the property, whether you're a cultivator or a dispensary.
Well,
There's
Dasney provided
there's a lot of requirements. Well, that fund has yet to come to fruition. They're having trouble. It sounds like they're having trouble raising the capital. A private equity fund. I'm just trying to remember it. So it's the Impact Ventures is the name of the fund, the private fund, which actually is headlined by Chris Webber, who's a former NBA player. They've had trouble raising the $150 million. The state was going to match $50 million of that to bring the total fund to $200 million. But that has yet to come to fruition. And I imagine that one of the issues is that this Impact Ventures fund is struggling to raise the capital for the reasons that I outlined. So hopefully, once things like the SAFE Act gets passed, once these applications really start flowing with the OCM and licenses really start getting issued, you'll see a significant increase in access to capital, and perhaps the actual funding of this social equity fund from New York State.
So speaking about the lawsuit, which we haven't done, the lawsuit for the 5 regions, one of my contacts said today the judge struck down New York State dismissing the case in the other regions. So they can't dismiss the case, or they did dismiss the case.
I haven't seen that news, so you're more on top of that than I am.
I mean, I haven't seen it either, but
it does seem to squarely, in terms of the lawsuit, I think the plaintiffs actually have a very strong case.
Sure.
I do think that the rule flies right in the face of that federal law.
Right.
So, I do think that they're going to have to open it up to out-of-state players. I don't know how that's going to play out exactly, but I'm surprised to hear that. Well, we'll see how it
Well,
shakes out.
actually, I don't know how to interpret that, but something happened.
Yeah, I'm trying to see if I can find it, because yeah, I didn't see anything on that.
Yeah, so, but I mean, again, it's, do you guys, and I don't want to put you on the spot, do you guys have any, hypotheses as to how that lawsuit will turn out? So some of the people I've talked to are like, it'll be dismissed, or the guy will just get paid out because he does this all the time because he's done it in other states, or they'll just ignore it and then open up applications to everybody. You guys want to put money on any of those options? And I won't hold you to it.
I'll defer to Will because this is more his territory, but I'm gonna, I mean, if he wants to take it, as far as he might need to take it, the plaintiff.
Yeah.
Yeah, and if he walks away with a bundle of cash and could care less about the principle,
Yeah,
the underlying principle.
he has no intention of opening a dispensary here.
Right.
No intention.
But
Because he
the
just did this
principle is
with, I
that,
think, Michigan.
yeah, I think the principle is a strong one. I think that it's going to be really tough. And again, I don't think that rule was final. I think he was just challenging the proposed rule. Am I right about that?
If you're talking about, I think his name is Versito.
Versites or whatever.
Yeah.
Yeah.
Yeah, it was based on the conditional rules, but depending on, again, I haven't seen that ruling that you were just referencing.
No, I know. I haven't either. I mean, his initial thing was based on the Dormant Commerce Clause.
Right.
Right. And so, but I mean, which, I guess we have a Department of Commerce, and that's federally regulated. So I can see that. I can totally see that. But yeah, I again, that was just from a contact that I've seen that would text me in the legacy market. So
Well, I think what surprised the legal community is that New York State wasn't out in front of it, because as you pointed out, Jennifer, he's done this in other states, and as you pointed out earlier, we as a state we should have learned from the mistakes that other states made, but apparently that was one that was overlooked. I have a feeling that they'll try to rephrase the rule in New York State to be compliant with the Dormant Commerce Clause, but also accomplish the goals that New York State is trying to accomplish as a state. I don't know how they do that. I'm not in the
can they
trust
do
over
that
there.
when like Manhattan can open a dispensary and Brooklyn can't, or vice versa? I don't have it.
It's mainly based on the way that the federal courts in New York State are separated. So this ruling came from the Northern District, so it affects 5 specific regions of New York, including Central New York and parts of downstate.
I thought it would only affected the 5 regions because those are the ones he indicated on his application that he would be willing to operate a dispensary in.
Yeah, that's the key.
Yep, and that's located here in the Northern District. So that's what gave the judge the power to sort of put a pause on all of those on the licenses and the applications that were submitted.
We've got a question from Wendy. Hold on. What about people who qualified for card but did not proceed due to not wanting to be in a state-owned dispensary? Then New York ended up changing the rules after the application window was closed. Is there any recourse? I get you, Wendy. Yeah, you didn't want to be beholden to having a building owned by New York State, right? You can turn on your camera or mic on if you want, Wendy.
Hi, thanks for letting me speak. I actually I am a consultant and I do have a client that did qualify for card. And he ended up not moving forward. And then, is there any anything he can do? I mean, they did end up changing the rules well after the fact the application window was closed.
Can you expand on that a little bit? I mean,
I-
why
Yeah,
did
so-
you decide
so-
not?
So what the OCM is like, if you were going to be if you were going to apply for a card dispensary, then you would have to be in a state-owned facility, and that's where they had
Mhm.
DASNY doing the build out and everything.
Correct.
And then all of a sudden they that went by the wayside because they couldn't come through with, the money or the funding or the properties. So they started allowing the approved card applicants to get their own space. So, we have people that qualified for it, but they didn't want anything to do with being in a state-owned building. And now, the rules were changed after the fact. Just kind of curious.
So I think the first pass at the regulations, and Bart, correct me if I'm wrong, but I think the originally it said if you were not, going to use one of these properties that were going to be provided by DASNY, you had to have been in a space that you were renting for, I believe, the past 2 years. So that's why many people who, were card eligible opted to wait for DASNY, because, with the issues that we discussed earlier, certain landlords will not accept rent from a cannabis industry. So that's why the state thought if DASNY controlled the property, that would, sort of mitigate that issue. But as far as potential recourse, I don't think anything officially has been announced. But there are, a bunch of people who are in similar situations who were specifically waiting on and relying on DASNY to come through with providing a property, and now they also have nowhere to go. So I don't think anything has come out, at least as of now, regarding that specific issue, but I'd be shocked if OCM does not address that.
Well, there are, I think, lawsuits in the works based on people whatever, Vericides or whatever his name is, last name, lawsuit opens it up to people that didn't apply at all because they thought they would be disqualified or not meet the qualifications because they did not want to be beholden to the New York State with rent. So there are probably going to be more lawsuits based on that, which is kind of similar to what you're talking about.
Yeah, in this country, you could sue anybody for anything, but
Sure,
that's
yeah.
definitely an available option. But Wendy, it sounded as if you were looking for something, I guess, more specific from OCM or some sort of statement from them regarding how they would sort of right that wrong. And I don't think, at least I haven't seen anything from OCM on that issue, but yeah,
It's an interesting question. I haven't come across a scenario like that. And
Might
I'm not that familiar with that particular tension. I wouldn't be surprised though. I wonder if they'll reopen the application portal for folks like that. That would seem to be the recourse.
Yeah.
Well, one of the attorneys that we work with closely, he put out a white paper saying that, that not just the person who sued is open to litigation, but anyone who immediately was told, oh, I wasn't arrested in New York State, so I can't apply, they now have grounds to sue.
Okay, then thank you very much for that. And you're right, if they kind of went back and forth about if you have a brick and mortar that you've had for a certain length, but then right prior to the application window opening, they said that it was mandated that you would have to go into a state-owned facility. So that's where it comes in, and I'd be more than happy to send my client to you guys and see if you guys think there's
Yeah.
something there that.
Well, the other thing, speaking just strictly for the city of Rochester, was, OCM can say whatever, but the city has to designate zoning. So we told people, I was part of the mayor's task force for cannabis businesses, is do not rent any property, do not buy any property until the zoning regulations have gone through. So there's that aspect too of, you got to wait for your local municipality to decide where you can actually have these dispensaries.
Yep, and I'm in Syracuse, so I'm in Onondaga County. And I believe, I know at least the city of Syracuse has indicated the proper zoning district. I believe a majority of the state has as well. But yes, those local municipalities can enforce their own code regulations and zoning regulations. And the city of Syracuse actually took a step to sort of curb the gray market that took off once the MARTA was signed. And what the city of Syracuse is doing is they're targeting, smoke shops and other businesses that are legitimate businesses, but are also selling cannabis, whether it be under the guise of a free gift or even just blatantly out selling it. They have signed into law that just for the sale of cannabis on your property, it's so many points on your business class. I think it's 4 points. And if you get a total of 12 points, your business can be shut down. And so a lot of these smoke shops that I know I've seen pop up all over the place in Syracuse are now being shut down because Syracuse took that first step and got their local government on board to set those zoning and code regulations. And like I said, I believe most of the state has followed suit, and if not, I know it's in the works.
I'm in Western New York, and we have several municipalities that are being very active in their zoning, and Jamestown was very similar. They were actually begging the OCM to help them with these illicit, the gifting and sticker shops. And so what Jamestown ended up doing was they just ended up pulling their certificate of occupancies, their COs. So they kind of shut them down that way, but it's very interesting.
Yeah, the gifting is an interesting thing. The way that it was put to me by an attorney that I greatly respect was, if you can take out the cannabis for sex, and if it sounds like prostitution, then it's wrong. So if I gave you this and you got sex from it, no bueno.
That's a great analogy.
Yeah, it really is. And it really holds legally, I believe. So if, think of it that way. You can't, yeah. So I've been taught by some of the best. So so yeah. Any other questions? Any other questions? There's got to be one. It can't be just me. Anybody? You guys were just so thorough.
All right, so I have a question, just only
There you
because I do liquor license, like, it's sorry.
Sure.
It's, what about anything, have they addressed anything about, gun ownership, pistol permits and licensees, as well as people that have their liquor license? And I know in MRTA, it does address it. It seems like that's okay, but then the state liquor authority, I don't know what their feelings are about cannabis, having a cannabis license as well as a liquor license.
Frankly, I don't,
That's not legal, is it?
to own both. Is that what you're asking, Jennifer?
Yeah. Can
I
you
don't-
do both?
I don't know, to be honest. I don't recall seeing anything prohibiting both. Bart?
I think I recall hearing about that. I haven't had that issue pop up with my clients. But actually, I think, yeah, one of my clients was considering partnering with a gentleman that owned a liquor store, and that got flagged. So I do think there is a restriction. And then we have, so I work with Will, I work with our licensing team in our Albany office. You know, we've got boots on the ground in Albany, and they really have their finger on the pulse of these regs. So when it comes to questions like that, you know, I rely on my Albany team mostly. But I'm almost certain that there is a restriction or a prohibition on having both a cannabis license and a liquor license in New York State. I don't know about the gun license rules. That's an interesting question.
I know in MRTA there is, it's very brief and it's like maybe one line. I can't think of it off the top of my head, but it does address, and it does seem to be favorable that you would be able to have both. But, I was hoping the regs would, address it, or at least have the state liquor authority come out and make a statement.
When
So-
you say both, do you mean cannabis and liquor license or
Correct.
cannabis
Oh,
and
sorry,
gun license?
no, liquor.
Okay. Sorry.
Yeah, again, I help out the Albany team with filling out those applications, and yeah, I don't recall anything specifically prohibiting both, unless someone's looking to sell both at the same location. I think that would be prohibited for
That's
sure.
it, That
Oh,
would-
yeah. That's
But I don't think there's any bar from holding both a liquor license and, a retail dispensary or consumption site license, so long as they're separate businesses. But I know regarding guns, at least, prior to, legal recreational cannabis, if you were a medical cannabis user, you couldn't also have a gun license in New York State and in other states as well. But again, I don't recall seeing anything specifically addressing that. I'd be shocked if, they said, since you have a gun license, you can't have a retail dispensary or a consumption site license. But yeah, I haven't seen anything, so have to go back and look now.
Yeah, I feel like I've talked about this before with somebody and I can't remember. So,
Well, thanks for addressing it. It's like, yeah.
any other questions while we have our esteemed William Wolf and Bart? I'm not going to say it.
Catch eye.
Yeah, that
Catch
guy. Kachai? Kachai?
Catch eye, that's it. There's a whole story behind it. I'm not going to go into it.
What does it mean in Italian?
Well, it's actually not even spelled properly, but the Italian pronunciation would be cachia.
Cachia, which means what?
From what I understand, it means some sort of growth on a tree. So don't go spreading that around.
Okay.
Have to make up a better story.
Well, my last name in Irish means raven. So, yeah,
It's a lot cooler than a growth on a tree.
it's a little better than a tree fungus, I admit. So I want to thank you guys so much for your time. You've been really helpful, and last call for questions. And if you would like to get a hold of any of these gentlemen, just contact me and I can get you in touch with them. But otherwise, you guys have a fantastic night. Good to see you, and all of the people that watched us on YouTube. We're so thankful that you tuned in. All right. Thanks,
Everybody.
everyone.
Thanks, everyone.
Have a great night.